So without further ado, here's Ryan.
Thank you so much. I'm happy to be here. Rental laws and regulations, it's not the most exciting topic, but I've learned a lot in preparing for this. As a lawyer, you might think that we have all the answers and we know everything. We don't, I assure you. And, for what I do, a lot of what I do is on the backside of all this stuff. I mean, we're handling cases, evictions. Very seldomly are we involved with property managers when they're doing the pre-application phase, the leasing and that type of thing. And so, we pretty much play the cards we're dealt. We see it on the back end, and sometimes we try to, give some pointers going forward. So it's nice to review some of this information, kind of at the intake level where people are coming in. So what I put together for you today is a brief summary. This was some topics that were given to me that I might wanted to briefly touch upon, and so I've done my best to assemble some information here that hopefully you'll find useful and helpful to you as you go in either in your property management business, your own personal portfolio of rental properties, or just your general education wanting to know more about this type of stuff. So as you mentioned, I'm a real estate lawyer here in town. My primary practice is real estate. I have a title company that does closings. I've been a lawyer for 26 years, give or take, and born and raised in Alachua County. So I'm an ACR. If any of you guys are ACRs out there, you know what that means. So anyhow, so we'll dive right in. So basically, we're going to touch on 6 categories. We're going to touch on discrimination. We're going to touch upon deposits, bad payments, normal wear and tear, evictions, and applicable law. So I'm going to do my best to not just read what I have for you here, but I'm going to kind of go through it. And then at the end, if we have time left over, we can sort of touch on some questions or maybe hear from you and talk about experiences you've had with dealing with some of these issues that I'll be raising today. So the first topic we'll be talking about is discrimination. Discrimination is probably the biggest issue. It's the one you hear most about. And hopefully it's the one that you seldomly have issues with. I mean, I can tell you in my practice that I haven't seen that as an issue from a legal standpoint very often. So I think that at least locally, people are doing a very good job of vetting their tenants and avoiding all the hot topics that could trigger a possible discrimination lawsuit. So keep the good work up. But there are some keys in order to help continue down that path of avoiding discrimination. And the first one I want to touch about is tenant screening. So tenant screening is probably the most important thing you can do as a property manager or an owner or an agent helping your client to make sure that you get the best qualified tenant for the property, and you can do it legally, effectively, and without violating fair housing laws or any other laws that may be applicable at the time. So do most of you here have a tenant screening process? Yep. And is that something you do individually, or is there a third-party vendor that you utilize for those services? Which is great. Okay, so that's good, because that's going to basically answer one of the questions. It's going to be consistency. So you're using a third-party vendor that's going to provide consistency versus you just taking somebody, and every time somebody comes in, it's like a different process, because that's going to get you in trouble if you just do it, case by case with every single tenant that comes in. So it's important to have a thorough tenant screening process to conduct the background check and things of that nature to make sure it's seamless. And it's also a good experience for the prospective tenant to come in and have a professional process. It's going to reflect well on you as a manager, and it's going to make them feel more comfortable about renting from you as a landlord. So here's some of the primary topics that come up during the tenant screening, things of which you may know, things you may not know. So the first one is that there is no application fee limit. It's very common nowadays to have an application fee. I mean, it's really twofold. I mean, the first component is doing an application review is time consuming, and it takes up your time, and your time is valuable, and it's going to cost your owner or client money. Plus, background checks cost money. So you're going to pass that fee along to the tenant. And the good thing about that is that's going to start the weed out process. I mean, I would encourage you not to charge $500. I mean, that's going to probably really weed out a lot of tenants that you're not going to want, but it's also going to weed out a lot of tenants that you do want. So the recommendation here is, maybe between $20 and $50, in which you would charge for the application fee, and then you may charge a similar fee for the background check. So what kind of fees are y'all seeing locally? 75 to 100. Okay. And that seems to be, I mean, I've been paying some for my daughter, and that seems to be what I've been getting charged. And of course, they're always non-refundable. So So anyhow, so that's something to keep in mind is the fee that you're charging to make sure that it's a good enough fee that will help provide some level of weed out, but it's not going to discourage good tenants from applying to your project. The second component, which kind of goes hand in hand with the application and what you're going to do, is that you must receive signed consent. So it's probably incorporated in your application. It's going to have language in there that says, you know, hereby acknowledge and agree that we can run a credit check, or you hereby acknowledge and agree that we can run a criminal background check through the FDLE. And so you want to make sure that's included, because if you just start doing those things, like if you do an application and they put their social security on there and you're like, well, I'll just take their social security and I'm going to run a credit check. You know, and it comes back and dings their credit, which it could. I mean, they could have a cause of action against you. So you want to make sure that all that stuff is included in the application. And most of you probably have very good applications. I mean, I know a lot of those applications are provided. You know, national levels provide applications. So just want to make sure that you have a good one that includes all the safeguards and all the consents that you would need as far as for management purposes. Of course, the fair housing laws still apply. Of course, the big ones that we always hear about: race, color, religion, sex, origin, family status, physical or mental disability. But nowadays you also have things such as accommodations. And I know for me, a lot of calls that I've received are about service animals or pets. I mean, you know, so those are always difficult because, you know, people say, well, it's my emotional support pet or it's my service pet. And, you know, it's very difficult. It's a fine line to walk with people nowadays, because it's not exactly clear cut on what you need to do in order to try to turn down somebody. And so I would just encourage you to be cautious. And, you know, I think there's even some restrictions there as far as the amount of deposit, pet deposit, dealing specifically with service animals. I mean, there's some restrictions that you need to be aware of, which I'm not going to cover today. You can't have a blanket policy regarding criminal history. So you can't just say, well, if you're a criminal, you're not qualified to be a tenant here. I mean, you'd like to be able to do that. It sounds reasonable, but you can't. So you have to be careful in your application process that you don't ask questions that delve too deep. And the key there is focused on convictions and not arrest or allegations. I mean, if so, you look up somebody and you see that they were arrested for narcotics or something like that, you know, but the case was ultimately dropped and didn't go to adjudication or judgment. Well, you can't really use that. They weren't guilty of a crime. But you know, the information is out there. So be careful with your policies on criminal history. There are no criminal record usage restrictions. So criminal information is pretty much freely available. You can go on, well, you can get it, but you can also go on Alachua County. I mean, I encourage all of you, as part of your own due diligence, to go onto Alachua County's court records information search and search your tenants. You'd be surprised the number of evictions that we receive. And I always look them up because I'm always just curious. I'm like, has this person had an eviction? And I type them in and I'm like, wow, one every year. And I'm like, well, you know, did these people, I mean, what kind of vetting did you do of this person? Because they don't seem like they're a very good tenant. I had somebody call about a week and a half ago, and we're doing eviction, and they sent me the lease over, and the name on the lease, I go, oh, I recognize that name. It was from like 4 months ago. There was another lease, an eviction that we did in Alachua, which had the same name. And in that case, the person was it was a fake. It was a totally like just a bogus person. I mean, they had a driver's license that was bogus. His employment status was bogus. And he was the guarantor on that lease. So these people were using the same person. I mean, he was the guarantor on this lease. And I'm like, let me guess, Georgia license? Yep. I'm like, yep, same person. So, you know, I say that because you could have searched that name and the tenant in this example, and you would have seen there was a history here, and you could have read about it. So I would encourage you to not only do what you're doing with the third party, but just go online. You'd be surprised the information you can find that's readily available. And if you have any questions about how to do that or what it means, you're always welcome to call my office. I'm happy to guide you or say, you know, here's how you do it. Yes, sir.
We have a resource called Forewarn for realtors. You put in a phone number, and I wonder if that's legitimate for us to use that. It's a background check based off a phone number.
Yeah, I mean, if you have resources like that that you can utilize, I think because I think it's communication is key to exchange information so that you don't have because what happens and what I see is patterns. You see these individuals oftentimes they just move around. I mean, they move in one, they get evicted, and are they they leave before they get the judgment. They just move on to the next one, and they just keep doing it, and they'll pay one rent or to put the deposit down, and then they don't pay, and then you're stuck trying to get them out for 3 months. And if they've done this, they know how to play the game. They know what they can do to buy more time. They call Three Rivers or something like that. That helps people. Sometimes buy more time. So I encourage you just to do your own individual checking, or if you have questions or you need somebody to help you, just give me a call. Yes, ma'am.
When it comes to taking multiple months rent up front, is it a bad idea to do like 6 months or 12 months, like they pay everything up front?
So, well, I see Justin shaking his head. So the caveat with that is if you start taking rental money up front, I mean, you're probably going to have to treat it as advance rent. You're probably going to have to put it aside, keep it in a separate account until it's accrued, until it's earned. I mean, that's, from a legal standpoint, I think it tends to be, if it's good funds, I think it's a good idea. I mean, if at least you got 6 months rent from these individuals. If they're going to do that, though, I would encourage you to make sure that they're good funds. I mean, make sure it's either a bona fide official check, cashier's check, or even maybe a wire. I would avoid, and we'll talk about this later, avoid, ACH, PayPal, Venmo, credit card, anything like that they could just come back in and dispute, and then you're stuck going, well, great, now I've got this big check about a great tenant, and now I've got a tenant and no income to show for it. So. And then the last one there, you must establish consistent criteria. So we touched on this with you're using a third-party provider. That's going to help keep consistency with what you're doing. I mean, you can't just have arbitrary standards for different people. I mean, you can set what you want. I mean, you can come up with levels that work for you. You just got to make sure you use those consistently across the board to your tenants. And you can change them. You're not locked in, like once you've set them, you can never change them. You just have to make sure you do it according to some kind of schedule that's fair and not unreasonable or arbitrary. All language that you use must be non-discriminatory. So in your application, hopefully everything that's in there is, as these questions have been through review, and they're not asking questions that are improper. So you just want to make sure that you don't vary from those questions and start asking questions that could end up causing you a problem, especially if you're doing any kind of interview or in-person communication. I mean, it's always best to have a paper trail demonstrating what it is that you guys discussed. I mean, you have those conversations. It's really a he said, she said. And if you do have those, then I would encourage you to just make a memorandum or just a note to the file. Like, John Smith came in today and we discussed his possible leasing at our apartment. We talked about these types of issues, that type of thing. It's just something to memorialize your conversation that you had should you ever need to defend yourself in court. With that kind of segues into you should monitor informal small talk. Just sitting there like, oh, I'm going to get to know the tenant, like, hey, where are you from? Well, somebody might construe that to be like, well, why are you asking me where I'm from? I mean, you're just wanting to know like where they're from. But so you do have to be careful when you're asking, because it could be an attempt to possibly discriminate against somebody who otherwise would be a qualified candidate for your property. And of course, you cannot lie or falsely advertise property. So you can't, have property available for rent and then have somebody call in and be like, we don't want these people. Sorry, it just got rented out. And if it's not true and they were able to somehow figure that out, you could be in hot water for doing something like that. So once again, just stick with the proper procedure. If you have good safeguards in place, you're going to largely avoid those problems and get the best tenants you can get. So let's talk about what potential tenants can I legally refuse to lease to. So now you have, okay, so maybe it's somebody you don't want to lease to. What are the grounds? What do you need to have in order to make that educated decision on whether to lease or not to lease to somebody? So what are the legal grounds to decline a rental application? So some of these are obvious ones, of course. Then the biggest one, and the most important one for you, is the income to rent ratio. I mean, obviously, if somebody doesn't qualify financially, it doesn't matter. Nothing else matters. I mean, that's it. You don't have enough money. You don't make enough money to live here. What kind of ratio are you guys seeing, or what's the general rule of thumb that you guys are utilizing? 3.5 times rent? Okay. So in researching it, I found a lot of reference to like a 3 times rent as kind of a general rule of thumb. But, in this day and age, I mean, it's probably, everything's gotten more expensive. And so 3.5, does that seem reasonable? Okay. So obviously you're going to run somebody and you're going to check the financial aspect. I mean, that's probably the first thing you should even do. I mean, because if they don't satisfy that, there's really no reason to go further. But if they do satisfy that, then of course you're going to start getting into those areas which are a little more tricky to navigate. The second one would be occupant level. You can't really discriminate based on occupancy. Like you really can't just say, you can't have more than so many people. So you're going to ask, like, get an idea of like how many occupants somebody is going to have. I mean, that should be part of your application. Is that on the application? Okay. So I know for HUD, well, we used to have some local regulations around here which restricted occupancy. I know growing up here, the rule was like no more than 3 unrelated people living within a house. And that was, I believe, the city of Gainesville's rule. Now that's no longer valid because of the governor. But HUD considers the general occupancy limit to be 2 people per bedroom. So I mean, I think there's some safeguards there. You can kind of general rule of thumb. I mean, I think other factors that I would consider would be parking situation. Of course, if you have a home that only can park 1 car, I mean, it having 6 people there with who each have 3 cars. I mean, it's just not feasible. It may not work for you. Yes, ma'am.
Also, if it's in within an HOA or a condo, sometimes their docs reference that. And so, like, one of the communities we manage has 2 people per bedroom.
Okay.
We also only have 2 parking spaces, so we should have something like that in there. But I didn't think of that until you said it. But
Yeah.
because we do have parking issues.
Right. So I think, so the tricky part there is going to be, is you're going to have to come up with something which you can defend that is justifiable. So, I mean, if take parking, for example, and I mean, honestly, I haven't researched that. I'm just talking out loud as a lawyer, that if you could show that it's unsafe in your community to have more than 2 cars per household because of maybe it's creating on-street parking or blocking, obscuring, I think those are things you can rely upon in order to base your decision upon occupancy. Or you can just tell the people, say, well, you can have 6 people, but you can only have 2 cars, or 1 car, or something like that. And then they're gonna be like, well, we can't do that. Well, sorry. Yes, ma'am.
Limits on how many kids can be in a bedroom, like, and gender, does that matter?
Right. So as far as I'm aware, and I'm by no means an expert on HUD, but I did read something about that really you don't count children. That's what I saw, that you're not really counting children as far as the occupancy levels. I mean, that's something I'd probably have to go specifically research further. Yes, sir.
So K-12, Oregon Washington County Health Authority does have an age limit in federal. So there are certain age, male, female, they have a.
Okay. And that's the city of Gainesville or? And the county housing authority. Okay. Okay. So good to know. So, yep. So, well, there you have it. Now, with that being said, I mean, sometimes, people will have things in place that theoretically could be subject to challenge, but certainly if they're out there, you definitely want to abide by those the best you can, in your housing. Let's see. All right. Okay. Bad credit, of course. Bad credit. You're going to run a credit check, and you can't just, once again, you can't just be like, oh, this person has a 650, I don't like them, but this person has a 600, they'll be wonderful. So you need to set that level and just create an established line of like what's your cutoff. And that's going to just automatically weed out whoever falls below that line. Unpaid balances and eviction. So this is one I touched on before. I mean, you can easily get information locally as far as eviction history to see if there's a pattern. You could find out if people have been sued for outstanding balances from rentals. There'll be judgments recorded in the public records, possibly. So those are just other useful things that you can consider. I mean, somebody could come in with an 820 score and theoretically have a really good job, but I mean, if they have a pattern of not paying their rental payments over the last 3 or 4 years, that may be grounds for you to say, I don't know, something just doesn't add up here. I'm just not. Yes, ma'am.
So on my application, I put like 650. If they do the application, I do the credit checks and everything, and it's less than that, is it fine to still make that decision and say, yes, it's not fit, $650, but it's not because of, credit cards being late every month or something like that, as long as I'm consistent with every single person that puts in the application doing that way?
So are you saying that this person has below 650, but you do want them to be a tenant?
Yes.
So yes, I think that, just because you say the line is 650, and if anybody who's ever under 650 is never going to be a tenant with me, that's not really what it's getting at. It's just, you have to weigh, because they may say, yes, but that's when I lost my job, but now I've been employed for a year. And as you know, your credit doesn't get repaired overnight. In credit, honestly, I'm not a big fan. It can be a good indicator, but it's also sometimes completely wrong. Sometimes people who pay all their bills, they just don't have a lot of credit because they don't use a lot of credit. And they could be the best tenant you could ever have and have the worst credit score possible. So I think you have to balance the two together. But you just need to have some established line that you utilize and then be able to back it up on why you use that. Of course, incorrect information. Obviously, if you later learn that information was false. So taking you back to my example that I had, that's how the case unraveled, was that they first determined that the occupancy was supposed to be like 2 people and there was like 8 people living there. So they noticed something was going on here, and they started diving deeper into the application that was submitted. Come to find out that the employment letter that was submitted on behalf of this fake person was falsified. It had, on the page 2, it had a different name on there. So it was like, so I encourage you, read your stuff. If they submit to you a letter of employment, read it. Don't just look at it and say, it says UF. Yes, UF. No, read it, because it might not even be their application, their letter of employment. So, yeah. And if you want to know more about that one, I'm happy to share more about it after today. We did get them out, by the way. All right, so incorrect information. So what are some invalid reasons, of course, to deny a rental application? So obviously, these are the ones that we've talked about. Obviously, the discrimination ones: marital, family, identity, religion, national origin, handicap, or age, color, race. It says, or other arbitrary discrimination. So, those are the big ones. Those are the easy ones. But then there's the other categories that you have to be careful with. And you just have to make sure that it's not arbitrary, that you have to make sure you can support that decision. That's a great question. It's not something certainly that I have researched as far as whether that person, not yet researched. My inclination would be, if you have somebody right now, then I would go with the safe bet. It'd be better to approve than to disapprove and run the risk of having an immigration lawyer.
It is a catch-22, right?
It is. No, you're certainly right. Exactly. So you may not know. You may not have that information. You certainly don't want to start asking those questions. Yeah, I know. There's a lot of things that have to be determined.
Most application processes have a question like, are you a legal citizen, or are you here on a visa, a work visa, educational visa?
I think they do. They do have those questions. In my experience, I don't think you can't just deny them, of course, based on that. But that information could be included on there. Yes.
About not allow friends to legal immigration. Someone that does not even have work permit.
Right. So I'm not an expert on that by any means. There's been a lot of stuff changing with that recently, of course, on whether you should be or should not be. I can tell you this, that they still have rights. Okay, they still have rights, and so I still think that the discrimination laws would still apply. Just because they may not be U.S. citizen doesn't mean that you can discriminate against them. So.
I spoke to somebody at immigration about, because I have a student and it just seemed a little wonky. And they said, it wasn't my job to determine if someone was in the country legally. It was just my job to determine if they qualified for the property. Yes.
Yeah.
So.
And then I would agree with that interpretation is, just do what you think's best and, try to stay out of hot water. Yes, sir, in the back.
Upfront like that, there's And we can hear you as a question.
All right, did you guys all hear? So just speak up to make sure they can hear the questions in the back, and if you can't, I'll just try to repeat them. Yes, ma'am.
They can't even go to the next step.
Right. Well, that very well may be true. I mean, you're going to have to, I suppose, you're just going to have to utilize the other tools that are available to your resources, to try to garner as much information as you can in order to make the best decision that you can at that time. All right. So what are the best ways to decline attendance application? So, you guys have all had to do this, of course, hopefully not as often as you would like, but it's going to happen. So these are just some suggestions that what you can do in order to do it. So that way, if you ever had to defend down the road, you would have something to defend that. So one thing you can do is consider writing what's called an adverse action letter to the applicant. So what do y'all do right now? I mean, somebody applies, you do the screening, and you're like, not approved. Do you just call them? Do you send them an email? Call them and then send them a letter. Okay. And I would say that's probably best practices. I mean, so in that letter, that's your opportunity. That's your CYA letter. That's I'm going to put stuff in here which supports my decision not to rent to you. And you just make sure it's based upon things that we've discussed or other criteria that you evaluated, which demonstrate that they just weren't a good fit for your property. If you don't respond at all, you just blow them off. It's not going to necessarily, there's nothing illegal about it. I mean, if somebody applies and they never hear from you again, yeah, I'm with you. I mean, right. No news is in that case bad news. But look, you can do that, and I get it. If you're a project where you have like hundreds of applications, maybe it's too time consuming. Maybe you just don't have the time, but you could easily come up with some kind of template or some kind of generic letter or something that that you could just send, and you could have some little.
I'd like to, is it a courtesy or we are obliged to respond?
Well, I mean, I think it's all the above. I think it's courtesy to let somebody know, because let's say if you applied and you didn't get approved, but they didn't tell you why. Well, I mean, if you tell them why, you're giving them feedback, and so maybe they can work on, like, you didn't qualify because of X. And they say, okay, and because you could tell them you didn't qualify because of X, and if you were able to get X fixed or do this or that, then come back to us and apply. That's a really good one, because then you're saying, it's not that I don't want to rent to you, I do want to rent to you, I just can't rent to you right now. So if you fix this, you come back. So I think that's going to always protect you. Yes, ma'am.
Would that fall, like if you ended up, if everything else kind of checks out for them, are you able to, is that arbitrary discrimination to say, like, you're not.
Like, you just didn't get the warm and fuzzy feeling, basically, of this person, or they seem like now you could hang your hat, and we're going to get to it. So you can, there's a category where you can kind of maybe determine if people are going to cause a problem for the community or something. I mean, I guess you really need to have it base that on something. That's going to be a difficult one. I mean, if somebody comes in, I mean, it could be they're just having a really bad day, or every day is a bad day for those people. Okay. So, I mean, at the end of the day, I mean, you're just going to have to make a decision that you can defend, based on criteria. And I don't think that alone, just like I didn't like the person, is going to work. You got to have something more to go on. All right, so you mentioned the adverse action letter. You can give the reasons why it was denied, and then maybe if there's a way that they could be reconsidered, you might want to tell them. I think that's good especially for younger people who aren't familiar with this process. It's just giving them feedback is going to help them, become a better tenant down the road. I touched on this briefly. Can I deny applications based on criminal records? So just a blatant policy, you can't rent here for being a criminal is not going to fly. But it is certainly a valid consideration. So I think, the information you need to consider were they convicted? That's the key, is conviction versus accusation or just charges. What was the offense for? the seriousness of the offense, how recent was the crime committed. I mean, if something was 15 years ago when they were, in college and stupid, that's not really a good indicator on how they're going to be today. But if it was the last 6 months, they've had 5 arrests for various things, that's going to be a lot more of a red flag for you. So if they had a long list of offenses or multiple offenses occurred over several years or around the same time. So I think you just have to do a holistic approach to look at that. Of course, once you have the details, I mean, there's certainly ones that would be easy ones. So if something they did put your property at the risk of vandalism or arson, I mean, if they were, charged for burning down houses or something like that, or, that's probably not going to be a good fit. Anything affects their ability to pay rent. I mean, they do not have a job. I mean, if they don't have a job, I mean, they're probably not going to get this far. Like, it probably didn't satisfy the income ratio, but, maybe they did. Sometimes people can demonstrate income other ways. And then, of course, making the environment unsafe for other tenants, say the convictions or things that would not be good for the community. Those would be criteria that are getting more acceptable, of course, to choose not to rent to those individuals. All right, so moving along to the topic of, yes, sir.
Is that, you said don't have blanket things that say nobody can, so how do you handle those?
Yeah, that's a good question. And, I don't know that the answer off the top of my head exactly what the policy is on if somebody, I mean, I would think, though, that, if somebody's on that list, that person falls within these categories of people that you potentially could say, sorry, I'm not going to rent to you. I mean, they certainly lost some of their other rights as well. I'd be happy to look that up specifically and find out if that's something that is a common issue. I mean, how many of you have run across that as far as your application process? You have. So maybe, thankfully not as common as one would hope, but that's something I'll make a note to check and see if there's a hard and fast rule on that, because it would be good to know.
You know what I mean?
Absolutely. Exactly. Because there are already things in place to control where they can go. And so the question, if you fall within one of those already, then it's an easy one. I mean, they just can't live there. I mean,
And they get put on the registry, and you're a mile from the school. You have to, if they're like, they have to stay. Okay, that's right.
all right, thank you. Now that makes,
Even if they're not next to the school, would you still have to?
You have to be within a certain amount of distance of the school, yes.
But if it's not by a school, and I just don't want that person in there because of that specifically, could you send somebody?
well, that's the question. Yeah. So the question we have over here is could you just deny them if they are in fact already on the registry? The secondary question would be is what happens if somebody gets charged for something like that after they become a tenant and the home otherwise qualifies as an area they could live in? So
But they have to be convicted, right?
absolutely.
They'd have to be charged and convicted of it.
They're on the registry.
Right, to get to the registration level. Yeah, so I mean, if they're not that far along, obviously, then you shouldn't even really be weighing that
Right.
as a direct.
You also got to see what the offense is.
Exactly. I agree.
Lot of field got as a predator because he was peeing on the field after a football game. So you got to be careful of what the charges are and see what the charges are.
And offender
point.
can be the result of a bad divorce or something like that. I mean, there's lots of.
Right, not everybody. I mean, look, there's a stigma associated with it, and I get it. But I mean, there's lots of examples where somebody, they really didn't do anything harmful to another person. They just, was either stupid, wrong place, wrong time, or whatever it is. So, yeah, so I do want to know a little more about that to see how that interplays with renting.
Business or, to confirm that is actual, that kind of income that the person.
I would suggest, I think it's wise to do that, of course. I would just make sure that you have consent or authorization in your application for you to do that. Because, I mean, you would hate to just start calling somebody's employer. I mean, what if he's relocating here for another job and he hasn't told his employer, and you're calling his employer saying, "Hi, I'm Sally, I'm in Gainesville, and this guy's making an application to rent an apartment," and they're like, "Really?" And then now you've potentially breached some kind of, confidentiality or whatever with your prospective tenant. So just make sure the language is in there. It could be very vague or very broad. It just gives you the authority to confirm and verify sources of income, things of that nature, so that you don't get caught in the middle of that. Yes, ma'am.
Kind of a question for everybody, with employment references now, a lot of companies like Walmart, Publix, UF, you can't just like call a supervisor or email a supervisor or whatever to get that information. They give you like, hey, you gotta go to this website, here's my credentials to log in, but it does cost us money. Has anybody run into that, and what are you doing? Are you signing up for these things and paying more money?
Meaning like they haven't started yet?
No, like, no, you call like even somebody like Walmart or Publix that's local and the supervisor, manager, whatever
But
won't
they've already
speak
been
to
working
you.
there.
Yeah,
You get
the
paid
manager
stubs.
won't speak to you, you gotta call this number, or you gotta do this, and it does have a fee. We ran into it quite a few times. It does have a fee involved, like you've gotta sign up in order to be the person looking up that information.
How much is
But
it?
it's a lot more companies now are doing this where they're not just.
I mean, I can see that being, appropriate for, big companies, think about it. I mean, they've got thousands of employees. I mean, it's all centralized to some, subsidiary or whatever who's handling that. As far as the fee goes, if you had language in there, something to the effect of, because you're charging an application fee and you're charging a background check fee or whatever, but you might not know about those fees. So, if you have language in there, like pay $50 plus any additional fees that we may incur, or something like that, because you didn't know about that, and it's not fair for you to have to pay.
Was already using that because we haven't yet.
Hmm.
But. I think so, yeah.
1-800 workforce. covers all
Yeah,
the
that-
different
yeah.
companies.
And how much are they asking for?
It depends on how many, I think, verifications you want to do a year. You get this much. Oh, right. I think.
But nobody's using it right now, nobody else. Okay.
All right, one question.
There's two ways that I actually done that. I actually have an actual employee verification form, so I like the rental verification form. I have them complete that, so whenever I don't have to go through that whole gamut, I just send that off to their current employer, and have them fill that out just like a landlord does. But then whenever they're going to have to go through that, I just have them log into their HR portal as the employee. If they're actually currently employed, they can just log in, and you can verify their employment right there.
You have them do that in the office? Oh, okay, okay.
All right, that's good. Well, that's definitely a good point. Verification is definitely important, and once again, not to beat a dead horse, but the one I had, somebody can give you documentation, but it's good to check behind it to see, because nowadays you can create anything. All right, so want to touch briefly on deposits. Most of you are well familiar with deposits. Section 8349 Florida statute is the statute that deals with deposits, and basically you have three options as far as deposits. You can hold them in the non-interest bearing account, which is probably the most common one that I see, which is, you just have to disclose that information to the tenant at the front end. You could put it in an interest bearing account. Interest rates have been higher in the last couple of years, so would it make sense? Unless the deposit is substantial, it probably doesn't really make sense to go through the time and effort of opening up an interest-bearing account. Plus, there's some interest-sharing type arrangement with the tenant. Probably more hassle than it's worth. Or you could do a surety bond type situation, which basically protects the tenant in case something happens to their money. But once again, there's always fees associated with that. Probably more worth time than it's worth, especially for residential leases that are, tend to be shorter term, 1 year or less. Claims on deposit, obviously, you guys have all had to deal with this. The statute covers that as well, like the process for making a claim, the time frame in which to do that. Of course, you have 15 days to return it, or if you're going to impose a claim, 30 days. The key here is just make sure that what you sent them is detail oriented, that it's specific. Outline what it is you're deducting from the security deposit. Don't just send a generic letter. There's damages to the home, we're keeping your deposit, see ya. Because that's kind of vague and doesn't really provide them with the information that's necessary. And know that if there is a dispute as to the security deposit, it's kind of carved out a little bit separately from general eviction damages work. So, I mean, if you keep a deposit and the tenant were to go after you for a refund of the deposit or even a portion of that deposit, and they prevail, I mean, if you kept $4,000 and the court says you're only entitled to keep $3,000 of it, the tenant's going to be considered the prevailing party in that action, and they can get attorney's fees and costs against you. So be careful, make sure you've documented it well, and you're prepared to defend. Yes, ma'am.
I'm just a small business myself. I don't know what it should say. The repairs themselves, am I able to do them and charge the going rate or whatever it is and charge for that? Or I've heard that it has to be some sort of handyman or professional or whatever it is to then charge.
Right. So my take on that is inherently, you know, I don't have anything wrong with somebody doing that work, but it's going to be an evidence problem. So let's say that you do the work and then you're going to go to a hearing and the court's going to say, you know, I want to see your receipts. I want to see your bills for this work that was done. And you're like, well, here's my bill. My time and all that. And they're not going to pay you for your time because you're not in the business of doing carpet installation. Like they may pay you for the carpet that you purchased, but they're not going to pay you $800 to install that carpet. So, I mean, if you're intending to go after the tenant for those items, then I would probably encourage you to use a third-party vendor, somebody who's furnished you with an invoice. Yeah, I mean, it could be your cousin. I don't care. Just, you know, something that's tangible that you could produce to show that this is what I had to pay to fix this. It doesn't, most of those people don't have to be licensed, you know, unless you're doing like electrical or plumbing or something like that. I mean, most of the stuff is just a handyman coming in and fixing it. So, yeah, so I had a case, and I don't want to talk on this too long, but I had a case which I was defending damages, and the plaintiff was seeking $17,000, of which, gosh, probably 12,000 of that was damages, and the rest of it was rental. And we had our hearing, and he didn't produce any invoices. His client testified as to the amount she had paid, but they didn't have any invoices or any receipts or anything, and the court blanked them on all that stuff. So they were seeking $17,000 and got judgment for $4,000. So just because she didn't have the documentation. So the documentation is going to be crucial, because without that, the testimony's it's not going to be credible. No, unfortunately, they still prevailed. I mean, even though they were seeking 17, they got a judgment for 4. So my client, I was defending, still had to pay legal fees. So we'll touch on that towards the end. You know, the pitfalls and the risk of bringing these kinds of actions, because, you know, even if you're successful, sometimes you don't really win at the end of the day. So, all right, touch on bad payments. Have you guys run into that frequently? Bad payments, chargebacks, things of that nature? Is that a problem?
Become a bigger and bigger problem.
Okay. And that's just could just be a sign of the times maybe, or you know, people getting. It doesn't take much. It doesn't take much, it seems, to dispute something nowadays and for them to pull the money out of your account. And it's a pain.
It goes 6 months, they've already moved out of the place, and then they're going back and disputing rent that they paid, that we've already paid to an owner. So do you have any, like, things that could cover us from a rental property? Like, is there something we need to put into our leases that might cover those types of situations? Because they're just going back and disputing stuff from 6 months ago when they don't even live in the house anymore.
Right. Well, I mean, you know, at the end of the day, you can put whatever you want in the lease, but I mean, it's not going to change what they do, and it certainly is not going to change what the credit card company or whoever may do. They're not going to look at the lease and go, "Oh yeah, see that provision right there." So exactly. So here's the scenarios that I'm seeing or hearing about as far as, you know, rent payment fraud. You know, we're seeing so ACH disputes where people are challenging those and they can pull that money back debit credit card chargebacks, which you guys just touched on, peer-to-peer fraud, so either Venmo or PayPal, things of that nature. I mean, people are using those things to make payments, and unfortunately, there's ways to pull that back. Offline fraud, so this would be either writing bad checks, counterfeit checks. I mean, we've seen plenty of those. We kind of got away. I mean, maybe we're seeing more of those. I mean, it's so easy nowadays to create a check of any kind, and somebody could give you a check on the front end. I mean, they've moved in before you even know that the check's no good. And now you're stuck having to try to get them out. Yes, sir.
So, that's certified don't have that, 'cause I had that when I first got it. Second, we process over 500, 600 rent payments every month. So my question is, the check, if they bypass the check that month, I can handle that. If it, tenant doesn't pay me 2,000 or doesn't stop paying me on a $2,000 check, I might be out $2,000. Problem we're having is the credit cards. And I think that's what she was trying to get at, is what can I do to go after the tenant or whatever, because what they're doing is they will pay rent 1 month, 2 months, 3 months. We're good because they're paying rent, it's clear, and we're paying owners and paying bills and everything. And then month 3, they go dispute. They're out of our property. Now I'm out $6,000 because it doesn't come out of the owner's account. It comes out of my operating.
Right.
So now I look and go, what do you mean I'm out 6,000? And I go in and see it's a dispute. Do I have to take that tenant? Because one, I have to go to the owner and try to get the owner from the money, hopefully I still have the property. I go to the owner to get the money. Or 2, do I sue the tenant or go after the tenant and try to get, blood out of turnip? Is this just gonna be a chalk it up to cost of the business? Because it's becoming very prevalent now. A lot of people starting to understand that they can do a credit card dispute real quick. And it's becoming, especially in the apartment association, during their meetings, it is becoming very popular with tenants to say,
Right.
dispute, especially when they're on their way out and they know they're gonna lose everything, they just dispute it and get all their money out. They haven't done an ACH. I've not heard anybody doing ACH. I've heard it all because an ACH, they got to initiate it.
Yeah, they have to go ACH, you're gonna have to go to the bank. And so just to respond briefly, I don't have a great answer to that. I mean, unfortunately, things that are going to happen. I mean, your cause of action would be twofold. You would have a cause of action, obviously, against the tenant for damages. I mean, even if you're successful and you get a judgment against them for $6,000, I mean, good luck collecting on it. Secondly, I mean, I would encourage you. I mean, that's the way I see that. That's stealing. That's theft. I would go file a police report and just document it. Let them. I mean, not that they probably won't do anything, but I mean, at least you've documented it, and hopefully it'll catch up with this person if they start doing that. You can certainly take it up with the credit card company itself, trying to go down that road, but good luck. I mean, you're just gonna waste your time, probably. Yes, sir.
Can you specify what type of payments you accept only, like check or cash? You can say no credit card.
Absolutely. I mean, you could. I mean, you're going to be saying. I mean, if you say I only take cash. I mean, a lot of people don't even like to take cash nowadays because of the inherent risk of that. I mean, you just got to document it and receipt it and all that. You could do certified or official checks. I mean, certainly if somebody, hopefully your agreement say something. If somebody writes you a bad check, you have the right to immediately demand that all payments going forward are, certified funds or something along those lines. You could wires. I mean, there are fees associated with wires, but wires are good. Wires are the best source of funds, because you can't get those back. Very difficult. Zelle would be like a Venmo or PayPal. I mean, I think that, through those, that they could dispute that, as a fraudulent charge of some kind, and they could, there's a chance they could pull that back as well. It's an ACH basically, and so they could. Well, they're all basically the similar type of thing, and all of them can be undone basically. I mean, there's very few things that you can undo. I mean, it's a wire. Go there you go. Yep. I mean, you could take crypto if you want, you know. Yeah, so most fees for wiring, I mean, you're going to have them on both sides. I mean, you're going to have a fee to receive wires. You're going to have, and they're going to have to pay a fee. But you know what? If you put that in the lease, that these are the only forms that you accept. I mean, if they choose to pay you by a wire, you know, or a cash, you know, cashier's check, you know, there's fees associated with that, but that's on them. Like they go pay that. Of course, there's no fee to you for somebody tendering cash or a cashier's check. A wire, yes, you get fees, but you can negotiate those with your bank. I mean, if you're doing them, you can go in and negotiate those down. I mean, I think I personally pay between $6 and $10 a wire, whereas, you know, some banks want to charge you $25. But, you know, if you talk to them and you're a good customer, then hopefully they can get that down for you. Because it adds up. I mean, obviously a lot per transaction. All right, so tips to prevent rent payment fraud. So here we are. This is the solution to all of our problems. So the one we talked about is conduct tenant screening. Of course, doing good screening is hopefully going to carry through the whole landlord-tenant relationship and going to help cut down on the problems you're going to have with payment, forms of payment, and certainly chargebacks. Understand the common fraudulent tactics. I mean, it seems like you guys are well versed on some of the things people are using. I failed to mention, I guess I should have said money orders or Western Union. Like those are pretty good funds. I mean, they're kind of a pain to deposit, but they are good funds. I've never had one of those returned. Really? Well, there you have it. So, yeah. So they like washed them and created new ones. So on checks, you know, one thing you used to be able to do, I mean, everybody's getting so leery and afraid to talk to you about anything these days because they're afraid it might come back to harm them, you know, especially banks. You used to be able to pick up the phone and call a bank and say, hey, I just got a check from you. Can you verify if it's good funds? And sometimes they'll still do it. Sometimes they'll be like, I'm sorry, you know, you're not our customer. We can't talk to you about the check. I'm like, I just want to know if this is a good check. But so it's still worthwhile to try to do some of the due diligence. Maintain good communication with your tenants. I mean, once again, it's a sign of a healthy relationship. If you have good communication with your tenants, hopefully they're going to be less likely to try to do something like that to you. Rent payment technology. I'm not an expert on this, but I guess there's some technology out there that one could use. I mean, I know we have like automated check analysis. So, I mean, you could get those, and I think that's going to help process checks faster. Hopefully, if there's an issue with the check, you're going to know it sooner than later versus taking it to the bank, and then the bank sits on it. And, you know, so if you're doing a lot of checks, it might be something to consider looking into, is to have your own check scanner. You can sit there and run through all day long. Inspect the payment instruments. As you mentioned, you know, sometimes you can look at them and go, this looks a little sketchy. And so so do look at them. You know, I would encourage you to look at them, even cash. I mean, these days, I guess you need to look at that too. And keep thorough record. So if you do have a problem, just make sure you've documented the payment, the income, keep a good ledger showing the payments they've made and all that. So because you're going to need those things if you ever have to go after the tenant. First thing I'm going to say is I need the lease notices, and I want to see the ledger, the rent ledger, showing the payments. And if you say, oh, I don't really have a ledger, I mean, we've got, you know, he paid me some in cash, he paid me some in money orders, he paid me some in Zelle, and you got payments all over the place. I'm just going to look at you and go, this can be a nightmare to try to prove how much they owe you in court. So just pick one and stick with it. All right, so moving along, it's 12 o'clock. I apologize that, you know, I have a lot of information, but I'm on the last couple of things. So I'm not going to go through it all, but we'll just touch on it. Normal wear and tear. So this certainly gets back to the damages component dealing with post move out and what is normal wear and tear. And so I've set forth here what I would consider some examples of normal wear and tear and also what's not considered normal wear and tear. And I think the pivotal question is this something the tenant caused? Like, did their negligence cause this to happen? And if the answer is no, then you have to say, well, okay, is this something that just happened? And so I put a bunch of examples of things that are and are not. I also included life expectancy chart for carpeting, flooring, appliances. So in the case that I had, of course, they were charging to reinstall all brand new carpet. but the carpet had already been there for like 4 years. And so, you can't charge my client for brand new carpet when the 4 out of the 6 years or whatever of the carpet life had already ended. You can basically assess them for an extra year that you lost. And so those are important things to keep in mind. Even if somebody does damage the carpet bad, you got to think about, well, how long has this carpet been here? I mean, was I going to replace the carpet anyway? And if it was new carpet, then certainly you're going to have a higher probability of getting a full reimbursement. And as you progress, you're going to get less and less as you go through it. So I've set forth there a bunch of other examples of wear and tear and what's just damages. Some of them are subtle. I mean, I've seen them on lists that landlords have sent me where they're claiming damages for things, and I'm just like, that seems a little bit ticky-tacky. Like that's a little bit, like the toilet's running. Well, those things that happens. I mean, they do wear out and they do run and well, exactly. But sometimes the people think the tenant, you damaged, whatever, kids messed it up or something like that. So I think you have to, really decide whether it's worth going down that road. And certainly if a tenant does push back with you as to your damages that you're claiming, you got to decide, is it worth going to court over? Is it worth, fighting over a few $1,000s? And I can tell you the answer to that question is no, it's not. It's going to take a lot of time. It's going to take money. And it's just stressful, like for people to have to go do that. I mean, my case that I had went on for like 2 years. I mean, my clients paid me $20,000 and they got stuck owing $4,000 and $8,000 in attorney's fees. I mean, but they couldn't do anything about it. I mean, they had already tried to work it out. They had already offered the lady $5,000 at the very beginning, which was more than she actually got at the end of the case. So it was really a bad outcome for everybody. And so there's just never going to be a good outcome in any of those scenarios.
All understand this is convincing some of our owners that they can't charge for what they think we should charge for. I mean, I don't know if anyone else.
Yeah.
And they're just like, you should have charged for this, this, and that. And I'm like, it really wasn't new when they moved in. Right.
Right. Yeah. And I imagine that's the rub you get. I mean, people are like, this place needs repainting. And you're like, you're going to have to pay for that. You go, why do I need to pay for that? I mean, the tenants, and I get it because they don't do this on a day-and-day basis. Right. Back to the you're not a painter. Yeah. And I think that's probably honestly the best practice, just because it creates other problems. So moving along to evictions. So that's really where I get involved. I mean, I don't see a lot of the front end stuff. We get involved with evictions. So here's my advice as far as evictions go. Don't delay. I see many, many times where people come in and go, this person hadn't paid rent in 6 months, 4 months, 3 months. Why are you just now coming in here? Like if they hadn't paid the first month, send them a 3-day notice. And I think now that you probably have reasons, okay, and a lot of times maybe you're trying to work with people and do workouts and things of that nature. But the other thing you're doing is you're enabling. Your people are going, okay, I see how this works, and I can just keep delay. But I mean, if you tell them front end, if you don't pay your rent on time, I will serve you a 3-day notice. If you don't pay the rent during that time, I will evict you. And if they don't do it and send them the notice, maybe it'll be a wake-up call. Yes, sir. The 30-day?
30-day, still.
Right. Yeah, so what he's mentioning is during COVID, when they passed the CARES Act or something like that, there was so much stuff in that thing, who knows what was in there, but they put in a little thing about tenants and having to provide a 30-day notice on HUD-backed. I think it was any property that might have a government mortgage or something like that on it. And so they left it there. I mean, they did away with most of the CARES Act, but that's still there. And I mean, it can become an issue. I mean, honestly, it's more likely not going to be an issue because, the way it works, as you know, is the landlord has the upper hand. So if you file eviction for somebody, I mean, even if you send them a notice that has a picture of Mickey Mouse on it, and and that's the only notice you gave them, and of course the notice on its face is invalid. Well, unless they've put the money in the court registry, it doesn't matter what notice you gave them because it's not relevant. they can't raise any defenses. So, yes, they need to get rid of it. Is it causing a problem? Not really. We had a case where they used the 30-day form for it. It was all messed up. It was a 30-day form with 3 days in it. So it was like the worst form ever. And, we filed it because we just, I sometimes don't read things myself. So we filed it, and it was like they got Three Rivers, and they're like, oh, this form is awful, 30-day notice. I'm like, oh, well, okay, well, let's see if they put the money in the court registry, and then we'll deal with the form. Of course, they didn't. So we never even got to it. So there are some protections for a landlord. I don't even take tenant matters currently. We had a lot of tenant calls, and I just don't do it because there's really such a disadvantage for tenants. Unless it's something so blatant and obvious where clearly the landlord has violated something, if the tenant doesn't have money, that's a problem. So, yes, ma'am. Right. So that the rules for the 3-day notice, is basically you're supposed to deliver the 3-day notice to them. And if they're not home, you're supposed to post it on their door. You can use mail. Now, there's nothing in the statute specifically that addresses emailing a 3-day notice. But if you're going to do an email, which I would discourage you from doing, but if you are going to do it, then you're going to need to treat that as mail. Like that's a form of mail. You're going to need to add the 5 days onto that. So, unless you absolutely just can't go to the property or you're afraid to go to the property or something like that, then just make sure you add the 5 days on there. But then if you're going to do that, you might as well just put it in the mail. So, because email, technically, they could object to that. But once again, if they haven't paid rent, that's not even going to come up as an issue. It shouldn't come up as an issue. Well, yeah. So for our landlords, what I ask them to do is, of course, keep a copy, print 2, post 1, fill out 1, keep 1, just so it's a good legible copy, and take a picture. If they want to dispute that they didn't get a 3-day notice, that's the best evidence. You say, well, here's where I put out. Certified mail? I don't believe it needs to be certified mail. It just needs to be U.S. mail, and then you have to add 5 days. So if you look at the statute it's attached here, you'll see that it talks about mailing, and you have to add 5 days for mail. Of course. All right, so don't delay. Just try to get those going sooner than later, because the longer you wait, the less money you're never going to receive. Yes, sir.
So actually, the receipt online, and it actually held in court, and it actually worked.
Good. And that's essentially, you bring that up because when I researched, because somebody asked us about that, and I had read, and I found a case, actually. Could have been your case. I don't know. But this was probably a district court of appeals case. But it came out, and that was the crux of the case, was that there was a read receipt that proved that the person had actually received it. And so, it overcame their objection.
Anything we send with owners, it's all through our systems, tenants are through our system, so it shows read receipts when they.
Yeah.
So, for that kind of stuff that we can have documents.
I would, yeah. So with your programs, which is great. It's great that you have programs, but I would encourage you, though, for any legal notices that you may be serving the tenant, whether it's a 3-day notice or a 7-day. Yeah, but also for your 7-day notices for curable or non-curable, things of that nature, I would always do the separate, a separate paper and serve it according to statute by delivering it or posting or whatever. Because utilizing your program and maybe typing it in that program and sending it to them, it may not work. Like it may not be sufficient. It may, they may, even if they got it, they may say, yeah, I received it. But if it doesn't satisfy the statutory criteria for what kind of delivery, it may, or, well, first, no, not for the 3-day, not for 3-day and 7-day notices. You just have to make sure you satisfy the statute. So, that's my point there. I'm not discouraging you from communicating through your portals and all that stuff. Just make sure if you had a problem that you do the separate document, call it a 7-day notice, and post it or deliver it the way you're supposed to do it, because that's going to be your evidence. After you serve a 3-day notice, you got to think twice about accepting the rent. You can accept rent, of course, after you serve a 3-day notice. You just know that if it's a partial payment, you're going to have to serve them another 3-day notice. So you can't serve them a 3-day notice. They pay you $1,000, and then you just say, you never brought me the rest of the money. I want to file my eviction. You're going to serve them another 3-day notice, which has the new amount in it. And on your 3-day notice, most of the leases you use deem any additional charges as additional rent. But just make sure that it does, because you can't charge for things that aren't rent on a 3-day notice. So, and then if you have filed the eviction case has been filed, and somebody wants to now tender money, you need to do one of two things. You need to tell them to go to the court and deposit it in the court registry, like don't take it. Or if you're going to take it, then it needs to be accompanied with a stipulation agreement that the tenant will sign, which basically will wrap up the case, basically. So that way you've got it all documented, and if they've breached the stipulation, you can just walk back into court and say, okay, they breached and I get my judgment. So just don't take the money. A lot of landlords would just say, well, we accepted a payment. They're like, why'd you do that? Because you've just messed up your whole case. So don't do it unless you have a signed written agreement. Pursuing damages after move out, may not be worth pursuing. I would encourage you, like most evictions we do are just for possession. I mean, you want to get the people out. You can couple it with damages at the same time. I don't really like to do that because I feel like it just slows things down. We have to serve a 5-day summons. We have to serve a 20-day summons. It's confusing for the tenant. The courts seem to never get it right. We're waiting on the 20-day, but the 5 days. You used to have a 5/20, like it was all in one, and then they broke it back out to 2. I would say just work on getting them out, because you don't really know what the damages are until you've had an opportunity to really get in there and figure it out. And then you can always come back and sue them for damages. I mean, it's a breach of a contract, so statute of limitations is 4 years, maybe 5 years. So you got plenty of time to do that. Plus, if it's a residential lease and there's months remaining, you can't accelerate. So in commercial landlord-tenant, you can accelerate the rents. You can say, you've got 5 years left, you owe me $250,000. In a residential lease, you can't say you've got 6 months left, you owe me $7,000. You can't do that. You got to wait till either the end of you can either sue them every month for the rent, or you can just wait till the end and then sue them for all of it at one time. So there's no rush there. Residential leases. Yeah, residential leases, you cannot accelerate rent and charge them all of it. And I think the reason behind that is it's just they don't want landlords to double dip all the time. Yeah, so the breach of contract, I think it's 4 years. It could be 5 years. It's a breach of contract action. So you have 4 years statute of limitations on that. The question was, what's the statute of limitations for a landlord bringing a cause of action for damages? So it's a breach of contract claim. I believe that it's 5-year statute of limitations here. Let me see here. Well, that's only if you took them to court. I mean, that's if you just want to bring an action against them to try to obtain a judgment against them. That's your time. Your time is running from the time that they breached the contract. Yes. So. Yep. That sounds right. Yeah. So you have lots of time. I mean, you certainly don't want to wait till 4 years out, but I mean, you might want to wait for somebody, because let's say they stop paying because they lost their job. Well, I mean, it's not going to do any good to just go sue them right away to get a judgment against somebody who doesn't even have employment. So you might want to give them some time to kind of get reestablished. And then if you did want to go collect it, well, then you have a better chance of getting a judgment and actually getting paid on the judgment. Because getting a judgment is one thing. Getting paid on a judgment or collecting on a judgment is very difficult. I mean, there's so many exemptions here for garnishment, things of that nature. It's very tough to get money from individuals, especially if they're married or head of household, things of that nature. All right, just some stats that I found for 2023-24 for Alachua County. The Florida court showed there was almost 2,200 eviction filings. And those numbers have been on the rise since COVID. There was also a study, Eviction Lab at Princeton University found that evictions in Gainesville are 46% higher than before the pandemic. So there's been a trend. I mean, I've seen an increase in my practice. I mean, it sounds like you guys have seen an increase not only in evictions, but also disputing payments and things of that nature. So not sure exactly what's going on. There's a website link here you can look up, has some more information about Alachua County and some of the sections and the areas, has like stats for individual areas of Alachua County that might be useful for you. If you're, looking at taking on management in an area of town, you may, look at and see, well, how much is, how difficult is this going to be, or that type of thing for, based on locale. The applicable laws that we've touched on, Section 8340 through 83683, that is the residential statute of the Florida statutes, which governs basically everything that you would need. I've got a copy of that. Well, I don't have the whole statute back here, but I have the deposit section, but that's the rest of it would be found in those sections. Section 76020 is the fair housing statute. And I would encourage you to read through that. I mean, one thing that was interesting, and you may or may not know this, but there are some exemptions. For example, I mean, if you have a single family house and you don't own more than 3 single family houses at one time, I mean, you can basically discriminate to some extent. I mean, basically, so you have a little more control over who you rent to. So, if you have an individual who's just thinking about renting out a house or whatever, make sure they're aware of that because they have more control over what they decide to do. Of course, there's exemptions for religious organizations, things of that nature. Yes, sir.
Companies now in Gainesville have actually sued because of the whole conversation of when somebody calls and says, do you accept housing? But we actually had one of our owners that went solo and started managing their own property, and he got the phone call from somebody, and then they tried to take support for that conversation. But because they had less than so many units, they actually won, but that was the conversation.
So I wanted to touch base on and that was on the Section 8 voucher program. A lot of people say, oh, I don't want to take Section 8 vouchers. I don't want to do that. Well, if you look in the Alachua County Code of Ordinances under lawful source of income, which is number 19, it basically says you cannot refuse to accept Section 8 vouchers on the basis of their status as a voucher holder. So you're going to have to consider their other sources of income, when doing your analysis. And, if you decide not to rent to them, it's going to need to be based on some other criteria, not just that. So just be careful. Obviously, you don't want to come out of the gate saying, we don't take Section 8. And then they say you have to, and then you go, oh, okay. And then you end up turning them down. You've already tainted the waters. I mean, they're going to just assume that you turned them down because of that. So make sure you're knowledgeable on how that works. No, I think no. So if you look at the Section 111, this is the Alachua County version. They also have exceptions. If you go down to 11141, I'm on like the 4th page to the end. It says exceptions. So basically, they're tracking the same exceptions that are found in the Florida statute, which also has an exception for single-family houses. So nothing in Section 11140, which is all the stuff that, basically you want to avoid, is applicable as long as you fall within one of these exceptions, which is the 3-house and under rule. So, I mean, now most of you guys are managing and it would apply to you anyway, but, if you have friends or neighbors or somebody who's owns a couple homes, they just want to rent them out, they need to be aware that, they have more flexibility in who they choose to rent to.
So that's like placement only. So if we market and we screen the applicants and we do the lease and then we turn it back over to the landlord to manage, would we be exempt from that Section 8 status because we are just a placement only, we're a screener? We're marketing it? Okay.
Yeah, because I think when you look at the definition, I mean, how you're Yeah, because because in that case, I mean, you could probably exempt a lot of people, because you are acting on behalf of individuals most of them very well may not own more than 2 or 3 homes.
Right.
Right. So,
Most.
yeah. So I think it's geared towards the homeowner just renting out their place, and not you guys. So that's a good question though. Well, that pretty much wraps up. I know it's a lot of information. I thank you for the time. I've learned a lot myself just because, like I said at the beginning, I don't see a lot of the process before it gets formalized into a lease agreement. I would encourage all of you to use a good lease agreement. A lot of you use like a national form, and just workshop it. Make sure you've got all the good language and provisions in there. Yes, ma'am. Right.
Some damage there.
Go back to
What
school.
they do, so they have all their land, or security deposit.
Right. So you're going to look, yes, you're going to have to look at the lease and see what it says as far as like the last month's rent. I mean, personally, I would prefer if people are going to collect first month's rent, security, last month's rent, I would rather just see you double the security, scrap the last month's rent, and just say that security deposit can be used to cover rent if it's not paid. Because what happens is you get caught in this situation, and we've had it recently where somebody's moving out at the end of the lease, and they haven't paid, or they're moving out early, and it creates a weird situation. Like they haven't paid the last month, but you had the last months, and they're wanting to get credit for it. And I don't know. It's just, to me, it's there's no real advantage.
You can give a cost damage, you can use the, security deposit to, fund the damage.
Absolutely. Absolutely. I mean, the security deposit is there for the purposes of mitigating damages to both the property and also to offset potential loss of rental income. And like that's what I said. Likewise, if you're going to require people to put that much money up front, then I would just get it in the form of the larger security deposit and a first month's rent, because you're supposed to hold advanced rent anyway. It's supposed to be held kind of in a separate interest-bearing account anyway. So there's really no advantage to you. Yes, ma'am. Yes.
Security deposit, so I understand the 15 days, 30 days, depending on if you're getting money back or so. But if the tenant moves out early, let's say it's 2 months early, and they intend to pay the rent, but they bring the keys.
Right.
Do you start the 15, 30 days when they drop the keys off, or?
Yes. I think the statute, you can see in the statute, I think it says, either upon the termination or earlier move out or release of possession. So if they've turned over and that they're no longer there, then that clock is ticking. Yeah. Yeah. Because I mean, it makes sense, because, you wouldn't want to be like, you got 8 months left on your lease. I'm going to wait 8 months, so yeah.
So I'm recently taking, again, the real estate licensing course, and in it, it does say that licensees, you cannot sign a lease for more than 1 year for residential lease.
So you're saying you can't sign it on behalf of the owner, or?
Straight out of the book.
I only ever see, I honestly, I only ever see 1 year leases, so.
Licensing for lease periods that do not exceed 1 year, provided licensees use forms that have been pre-approved by the Florida Supreme Court.
So they're saying more about preparation, huh?
But what I'm saying is it can't be like, we've signed leases, because the owners agree, yeah, we'll keep the rent the same, and they'll sign a 2-year lease. But what I'm reading here, it doesn't sound like. You're saying you have to agree. Yeah, no, No, well, you have to fill that in, but it still says that do not
It's
exceed
still
1
relative
year.
to the fire bar lease. She's talking about fire bar. Most of us have our own leases. I would assume, like, a lot of people aren't using a fire bar lease.
Well, I don't think ours is far more lease.
I don't know the answer. I don't know the answer specifically to that. I mean, my tendency would be is if you have the appropriate authority from your owner to enable you to do all these things, you can sign for whatever it is that they could sign for. I mean, if you have it properly documented.
Yeah, and in the past, you had to have it notarized, you had to have.
Well, there's no requirements for notaries. There's no requirements for witnesses anymore. Yeah, no, I mean it's good, especially for somebody who was, if they want to challenge. Like I didn't sign that,
Well, no.
Exactly. Yeah. Yeah.
Real quick, I was just telling about them, so with the FJ and M visas, you can do a background check on those students or workers through checkr.com. So anybody who actually goes through that kind of stuff. I actually had some students this past year who had the J visas. And they were the ones who told us about that website.
That's done. Think you can sign a card.
Yeah.
Check.
The letter R?
Yeah, so when I used to work for, Contemporary Management, they actually used the different software systems. They did background checks through international software, so it was a lot easier, but yeah.
Thank you. Sharing that.
Awesome. Thanks.
Well, Ryan, thank you on behalf of everybody that came.
Thanks,
for
Ryan.
dedicating
All right.
their
Yes.
time
Thank
for
you.
us.
Yeah. Thank you so much. Glad to come talk. So, okay.